but it's way too little for something as broad as the topic I'm going to talk about in the next and remaining 30 minutes of this legal track. Of course, that topic can only be very roughly addressed in this short time, but I hope I can provide a first overview. So, starting with, I can follow up on something Harald just said in his second last slide. When you start set up a PPT slide, you should. Sorry. Okay, when you start setting with the setup of an compliance program, you usually have to start at grid zero, meaning you have indeed to convince your management about the need of a compliance program. So I would like to start with the typical 6 misjudgments of management about open source licenses. Continue with some overview about actual steps that need to be implemented. And I would like also to expand a little bit on some tools that may help with open source compliance, and close, if the time is there, with a few of the mistakes to avoid. So now, here are the top reasons why your company don't need to comply with open source software and licenses, and of course why they are wrong. Undisputed number 1, of course, is we don't use open source software. I guess at this conference I don't need to say much about how wrong this is. Open source software made a great landfall for corporate use, for economic use. So in fact, most products involve open source software nowadays. Harald just expanded a little bit on how true that is for embedded devices. We know major parts of the internet work and run on open source software. Mobile platforms, a major topic of this conference, they are almost all partly or entirely based on open source software. And even in desktop computing, open source software is present beyond Ubuntu and SUSE. It is, we know Mac OS X is based on the Next Step kernel, which is derived from BSD, which is open source software. And even in the world of Microsoft, open source software is present. I believe Lucien said something about that in his presentation. And indeed, Microsoft had a GPL violation last year. They had one of the tools in Windows 7 was, as a matter of fact, derived from a GPL software. So Microsoft, I tend to believe that they didn't know about that, and they immediately fixed the problem by releasing the source code. But it shows, even for a company like Microsoft, the approach to say, we don't use open source software is an ill-conceived approach. You definitely have to start with saying, most probably we do, and only if you really find out we don't have any open source software. You can say that, but it still might not be a reason to not take care of some compliance program, because what you don't do today, you might do it tomorrow. Another epic failure is to think open source softwares are not enforceable, the licenses are not enforceable, or at least they are not enforced. I mean, that they are enforced, we see here. Harald Welte is here today. He is the founder of gplviolation.org, and they are enforcing the license. Also, others do. And now that more and more companies are using open source and fairly contributing to source code, you will also see more and more companies enforcing the licenses. Because, of course, if they have to share the intellectual property, and then they see other companies using it, maybe even their competitors, and they don't share back the source code, then, well, they will enforce the license. And that's actually happening now, and that's actually happening from a company that is in the sponsor list today, pretty much on top of it. So,
secret, please.
Okay.
请保密.
All right. Okay. So, but it's also not true that the licenses are not enforceable. There are a couple of cases in many jurisdictions already. I only want to share a few of them here. 3 of them. Welte, that's the very Mr. Welte is here today. versus Skype in Munich. Skype was distributing a Skype phone based on Linux and without distributing the source code. So they actually poured out each and every possible and impossible defense against the license. They said it's a violation of antitrust law. It would contain general terms and conditions that would be invalid under German law. Well, the court dismissed them all, and the court also asked, and that's interesting, they asked the question, where's that defense leading to? It will only lead to, if ever, the license is invalid, and if it's invalid, then you don't have a license at all, so you're still in violation of copyright. This court decision also made pretty clear that there is no such thing as complying a little bit by, for example, forwarding somebody to a third-party source of the source code saying, well, we didn't modify the kernel, so you can download the very same source code from kernel.org. That's still not complying with the license. Jacobson versus Katzer in the Northern District of California was a case about the artistic license, if I remember right. So here it was remarkable about this is that the court there hold that the non-compliance with the license, or the obligations in the license are not just obligations under the license, they are conditions to the license. So if you don't comply with them, then you're not just in breach of a contract, it means you don't have a license at all, you have a full-powered copyright infringement. And that will award much more rights to the copyright holders. It will entitle the copyright holder to injunctive relief, to damages upfront, maybe to account of profit, and in some cases you might have to turn over the products that are infringing, which can be very disastrous for a company. In that respect, I would also draw attention to a recent case. The Software Freedom Conservancy sued 14 companies who adopted BusyBox in violation of the GPL last December. I only named some of them here. Most of them by now settled the issue. At least one settled not, that is Westinghouse Digital. They didn't settle because they filed for general assignment, which is a kind of insolvency under California law. So they didn't defend anymore against the lawsuit. That has to be set for accuracy. It was a default judgment, but remarkably, triple damages have been awarded, and also that, of course, injunctive relief and all infringing products had to be turned over to be given to charity. Now, nothing against charity, but actually for an intact company, it can be quite disastrous if that happens. It can actually lead to insolvency. So, well, another big problem is that companies think, oh, well, our customers don't care about it. Well, if you are an end consumer brand, then usually the copyright holders are amongst your customers and they will care. Organizations like Harald's GPLviolation.org act based on specific complaints, and I think he can tell you that there are many of them. The products are exposed to the market, so end consumer brands cannot hide. Now, if you're further upstream in the supply chain, you might say, well, that's not our problem. But it is your customer's problem, because your customers are the end consumer brands, and they face the legal risk from this, from incompliance in the supply chain. So even if they don't tell you that they care about compliance, then they only do so because they don't know it yet. Another big problem is there's always a reason to say somebody else in my company will take care of it. You, the engineers, might say, well, that's a licensing issue, that's a legal department's call. But the legal department, they never heard anything about source code, build script, or something like that. So they will tell you, well, it's definitely an engineering department's call. And you all will agree that your supplier will actually has to take care of it. As a matter of fact, everybody needs to contribute his part to compliance. So one more remarkable sentence which I heard is we use so little of open source software, we can handle it informally. Of course, that's deceptive, because if you don't manage it, you don't know how little or big it is. Finally, doesn't affect our company so much, but it needs to be mentioned. People might say we use open source software as a service. So we have a .com, for example, and we grant access to the applications to users over the internet. That's not distributing the software, so we have no problem with distributing open source source code of the software. Well, to some extent that's right, but only to some extent, because first of all, there are also open source licenses that where the obligation to distribute the source code is already triggered when you grant access to the use of the software via a network. That's, but so far the only one is the AGPL, the Affairs General Public License. But there's one more thing to consider. If you found a .com or something, usually the ultimate goal you have is that it's so successful that Google will come and offer you billions for it. And if you do that, if you sell the company, then at that point in time, you might be distributing the software. So if you have all your business model implemented into the source code, and at that point in time you have to distribute the source code and publish it, you might have a problem then. So this tells us open source is ubiquitous. It needs to be managed, and it cannot be managed informally. Process implementation is critical. So you should start, when you implement a program, you should start by appointing a company-wide central person which will take care of the overall process, a compliance officer or whatever you call it. This person then has to make sure that he gets management's support for the compliance program, because of course there might be some resources need to be allocated to the compliance program, and that needs management support. So that is, as I said, you are starting with grid zero. It's maybe even the most difficult part in the whole overall process. When you have that secured, you need to start by analyzing what open source software you're using in the company and you might be likely to use in the near future. You have to look at the software licenses. You have to find out if all the license terms are acceptable to your company. And in that regard, you might have to define approved use for some of the licenses. Well, then you finally can start defining the processes and delegate the responsibilities to the people or to the involved departments. When you set up standard operating procedures, it is very important that you have integrate this procedures into your existing work environment. It doesn't help if you just make something that looks nice on the paper, but your company doesn't understand it and cannot implement it at all. So verify your SOPs, get feedback from the product managers, and if necessary, revise it. And do this over and over again until you have something that fits. Finally, even if it's fitting perfectly, if it's just on the paper and nobody knows it, it doesn't work for you. You have to publish the policies, you have to educate the employees, and also over and over again. And finally, of course, you're never done. You have to stay flexible and adjust to developments and improve the license compliance program. So, well, what processes are required? I mean, Harald actually was going a little bit more into details than I'm going to do, because giving you details here, aside from the fact that the time is much too short for that, it won't help you, because as I said, you have to define processes that fit your own company. But what you have to take care is you have to have code management. You need to know your code. Many companies just throw in open source code into their product because it's free, but that ends up with a mess. And at the end of the day, you don't know what's in the software, you don't know why it is in there and why it is supposed to be in there or allowed to be in there, and it's, at the end of the day, totally impossible to comply with the licenses. You need to have a license management, as I said. You need to review the licenses, you need to define approved use cases, and you should come up with or your legal department should come up with a green list of approved licenses. Very important, especially for us, is inbound compliance. I think it has been said in one of the previous presentations